Breaking news from the State House. One of the big bills in front of the Senate, the assault weapons ban, just passed.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruen decision,
saying setting a higher threshold in an emergency could mean life or death.
In the U.S., the U.S. Supreme Court is hearing arguments on a $10 billion lawsuit.
The Supreme Court has successfully dodged the most important Second Amendment question in American gun rights litigation for over a decade, but a new petition just filed might finally force their hand. This isn't another vague constitutional challenge or a technical procedural dispute that lets the justices avoid the core issue. This is a direct surgical strike at the heart of whether the government can ban the AR-15, which happens to be the single most popular rifle in America, and somehow claim that's constitutional under the Second Amendment. The petition filed by Connecticut gun owners is so precisely crafted and so strategically focused that legal experts are calling it one of the strongest challenges to assault weapon bans ever submitted to the Supreme Court. Once you understand how this case is different from every other gun ban challenge, why lower courts have created a complete mess of contradictory rulings, and what the justices wrote in previous cases that basically predicts they'll have to take this case, you'll realize we might be watching the most consequential Second Amendment case since Heller and Bruen combined. We're diving into a major new legal development that could fundamentally restore Second Amendment protections across the entire country. And frankly, this could be the case that finally forces the United States Supreme Court to answer the constitutional question they've been strategically dodging for years. Can the government ban the AR-15, the most popular rifle in America, by a massive margin, and somehow get away with calling that constitutional? Connecticut's ban on what politicians label as assault weapons is now officially headed to the Supreme Court for review, and the legal petition filed by the plaintiffs represents one of the strongest, most direct challenges to these categorical firearms bans that constitutional scholars have seen in modern litigation. The petition has been carefully reviewed by legal experts, and Connecticut state officials defending the ban are going to face an absolutely brutal constitutional fight if the Supreme Court decides to grant certiorari and hear this case. The Connecticut Citizens Defense League, abbreviated as CCDL, and the Second Amendment Foundation, known as SAF, have joined forces with individual plaintiffs Eddie Grant and Jennifer Hamilton in petitioning the Supreme Court to strike down Connecticut's sweeping assault weapon ban. This is fundamentally the same type of categorical ban that currently exists in jurisdictions like Illinois, New York, California, Massachusetts, Washington State, and several others. But this particular petition brings something genuinely new and strategically different to the Supreme Court's attention. A direct command-style question for the justices that eliminates any ambiguity about what constitutional issue is being presented. The petition asks whether the Second and 14th Amendments to the United States Constitution guarantee the right to possess semi-automatic rifles that are demonstrably in common use for lawful purposes, including specifically the most popular rifle in the entire country, the AR-15 platform. It's direct, it's precise, it's to the constitutional point, no procedural games, no tangential side issues, no confusion about what's being asked, just one crystal clear constitutional question. And that's exactly why this case is so potentially dangerous for anti-gun states and so critically important for the future of Second Amendment jurisprudence. Connecticut bans the sale, transfer, and possession of a massive list of firearms that state legislators have labeled as assault weapons through statute. But here's the fundamental truth that this petition makes crystal clear through extensive evidence and argumentation. Assault weapon is a political creation, not a legitimate technical category based on how firearms actually function. It's a term that was deliberately invented in the 1980s specifically to confuse the general public about the functional difference between fully automatic machine guns, which have been heavily regulated since 1934, and normal, ordinary semi-automatic rifles that fire one round per trigger, pull just like millions of other firearms.
It's a case that legal experts will be watching closely.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
It triggers something in me that something has to be done.
Well, later today, a landmark civil rights case is set to be argued before the Supreme Court.
This is a case that's been bounced around back and forth throughout the court system.
Under Connecticut's statutory scheme, if a semi-automatic rifle possesses any of certain cosmetic features that legislators don't aesthetically approve of, or if it can accept detachable magazines, which is standard for modern firearms, or even if it has a barrel length or an overall length that falls outside arbitrary measurements politicians selected, it becomes labeled as an assault weapon and completely banned from civilian possession. Violation carries felony criminal charges, including mandatory jail time under state law. The law specifically bans over 70 individually named firearms by make and model, plus broadly worded provisions covering copies and duplicates of those firearms, plus pistols equipped with stabilizing braces, plus AR-style rifles as a category, plus rifles with basic ergonomic features like adjustable stocks or pistol grips. It's functionally a complete ban on the most commonly owned rifle pattern in the entire country. The petition absolutely hammers this statistical point throughout its argumentation. And if the Supreme Court remains faithful to the constitutional standards they established in District of Columbia v. Heller and New York State Rifle and Pistol Association v. Bruin, Connecticut's ban simply cannot survive constitutional scrutiny. Neither can any of the other similar state bans currently in effect. Let's examine what this petition systematically lays out through extensive evidence and legal argument. First, AR-15 platform rifles are unquestionably the single most popular rifle type in the United States by an enormous margin. Conservative estimates place 20 to 30 million of them in civilian circulation, though many experts believe those numbers are significantly understated. More AR-15 rifles exist in American homes than Ford F-150 pickup trucks exist on American roads. Survey data shows that 16 to 25 million individual Americans personally own at least one AR pattern rifle. Second, Americans use AR-15 rifles for entirely lawful purposes every single day across the country. Gun owners consistently report using AR pattern rifles for home defense, property defense, recreational target shooting, firearms training, hunting various game species, protecting self and family during emergencies, and preparing for potential breakdowns in law and order. The National Shooting Sports Foundation's own data demonstrates that millions of people train with these rifles annually for lawful purposes. Americans use these firearms for precision shooting at extended ranges, for competitive shooting sports, for target shooting, and for home defense applications as well. Third, actual crime data completely destroys the dangerous and unusual classification argument that gun control advocates make. According to FBI uniform crime reports, rifles of any kind, including AR pattern rifles, are used in an extremely tiny fraction of total homicides annually. The data shows that handguns are used in homicides 18 times more frequently than all rifles combined. Knives and edged weapons kill more people yearly than rifles. Even hands and feet, classified as personal weapons in FBI statistics, kill more people annually than rifles of all types. If Connecticut's logical framework were applied consistently to actual crime data, then handguns would need to be banned first, which the Supreme Court already rejected as unconstitutional in Heller. The Second Circuit Court of Appeals upheld Connecticut's ban on appeal, but their legal reasoning was so internally contradictory and constitutionally questionable that the petition practically dissects the appellate opinion line by line. The appeals court admitted several things in their written opinion that undermine their own conclusion. They stated they were confused about whether AR-15 rifles even qualify as arms protected under the Second Amendment, which is a remarkable admission. They applied a significantly watered-down version of the historical tradition test that Bruin requires. They deferred heavily to legislative policy judgments, which Bruin specifically and explicitly forbids courts from doing. Most remarkably, they concluded that a firearm can somehow be classified as dangerous and unusual, even if millions of law-abiding citizens own it for lawful purposes. That's the exact opposite of what Heller established as constitutional law. The petition calls this logical impossibility out explicitly and forcefully. A weapon simply cannot be both in demonstrable common use and simultaneously unusual. It's logically impossible as a matter of basic reasoning. This internal contradiction is precisely why the Supreme Court needs to take this case and provide clear guidance. The lower courts have created absolute chaos through contradictory rulings. The First Circuit says AR pattern rifles are constitutionally protected arms, but they can be banned anyway based on legislative judgments. The Fourth Circuit says AR pattern rifles aren't constitutionally protected arms at all. The Seventh Circuit characterized AR pattern rifles as basically military weapons unsuitable for civilian use. The DC Circuit analyzes lethality and availability of alternative firearms. Different circuits place the common use analysis at different stages of constitutional review. It's a complete disaster, a judicial patchwork of fundamentally contradictory constitutional interpretations. The petition's most constitutionally devastating argument is this historical point. AR-15 rifles are the direct modern descendants of the rifles American colonists used to secure independence from Britain. That's a powerful historical framing that reminds the Supreme Court that repeating firearms existed in the 1700s, that high-capacity arms existed long before the AR-15 was invented, that semi-automatic firearms have been in common civilian use for over 140 years. The Founding Fathers themselves embraced technological advancement in firearms. From the Belton flintlock that could fire 16 shots in rapid succession to the Girandoni air rifle that Lewis and Clark carried on their expedition, the historical tradition is absolutely clear. If a weapon is demonstrably in lawful common use, it cannot be categorically banned. Period. The petition extensively quotes Heller, Bruin, Catano, and even individual writings from Justice Gorsuch, Justice Thomas, Justice Kavanaugh, and Justice Barrett throughout its argumentation. They even specifically cite Justice Kavanaugh's warning from earlier this year that the AR-15 question must be definitively resolved in the next term or two. This is that next term. They're practically begging the Supreme Court to grant certiorari and take this case for review. The petition explains systematically why this case is procedurally clean and strategically perfect for Supreme Court review. It presents only one constitutional issue with no distractions. It demonstrates a clear circuit split with contradictory rulings. It addresses a matter of massive national importance affecting millions of gun owners. It directly challenges a ban on the most popular rifle in America with no procedural complications, no additional legal claims muddying the waters, and no technical flaws that would allow avoidance. Plus, this petition comes from the Second Amendment Foundation and Connecticut Citizens Defense League, two organizations with extensive experience litigating these cases with precision and expertise. If the Supreme Court wants to reaffirm or even clarify what common use means under the Second Amendment so that lower court judges finally understand the constitutional standard, this is the ideal case. This could genuinely be the most important Second Amendment case since Bruin and Heller. Depending on what the Supreme Court decides, we could see Connecticut's ban struck down, Illinois' ban invalidated, California's ban overturned, New York's restrictions eliminated, Massachusetts, Washington, all of the assault weapon bans currently in effect. They're all potentially on the constitutional chopping block if the Supreme Court takes this case and rules consistently with their previous precedents. That's it for today, folks. See you in the next video.